Thank you, my Lord. My Lord knows I represent Mr. Saadallah. Miss Morgan represents the respondent. We both appeared in the court below.
Yes.
This is an application for leave to appeal against the sentence imposed upon Mr. Saadallah on the 11th of January of this year. Mr. Saadallah having pleaded guilty on the 11th of November the year before to 3 counts of murder and 3 counts of attempted murder. All offences arose out of the one incident in Forbury Gardens in Reading in June of 2020. The basis upon which Mr. Saadallah pleaded guilty was not acceptable to the prosecution, and as a consequence of that, there was a trial of issue for Mr. Justice Sweeney on the 4th and 5th of January of 2020. Following that trial of the issue, and on the 11th of January, Mr. Saadallah was sentenced to life imprisonment pursuant to Schedule 21 of the Criminal Justice Act 2003, and was made the subject of a whole life term. My Lord and my Lady will know the legislative framework and Schedule 21 very well. And the issues that arose in this case were that Mr. Saadallah disputed principally 2 key submissions made by the prosecution, the first of which was that there was a substantial degree of premeditation or planning. And secondly, that the murders were done for the purpose of advancing a political, religious or ideological cause. Either of those 2 features would elevate the sentence to a whole life term rather than the 30-year starting point. And although no evidence was called in the Newton hearing, submissions were made over the course of the 2 days, and the learned sentencing judge found that there was a substantial degree of premeditation and planning, and that the murder was done for the purpose of advancing a political, religious or ideological cause. It was our submission in the court below, and is here today, that the 30-year starting point, minimum starting point, was sufficient in his case, with significant upward adjustment to reflect the aggravating features that plainly exist in this case. The court will be aware that not only are features of premeditation and ideological causes introduced for the whole life term, those features are qualified further. The premeditation or planning must be substantial, and the ideological cause must be more than an interest or a link. The purpose of the murder must be to further that ideological cause. Because we conceded in the lower court and concede today that there is evidence of planning, that much is impossible to deny, and there is a link to an ideological cause. Our submission is that neither reaches the threshold necessary to impose upon him, upon Mr. Saadallah, the whole life term. We say the judge erred in that respect, and if I may, set out our submissions in respect of each of those 2 features, starting with a substantial degree of premeditation and planning. We submit that almost every criminal offence involves a certain degree of planning, other than those spontaneous offences. The premeditation required to justify a whole life term must be substantial. Nothing short of that will do. In Mr. Saadallah's case, as I have already conceded, there is evidence of planning, but nothing which gets close, we would suggest, to overcoming the threshold in Schedule 21, paragraph 4. The planning and premeditation present in his case was no more than that which was necessary to commit the offences. We would submit there must be significantly more to justify what is the sentence of last resort. As part of the trial of issue, the prosecution and then in turn the learned judge demonised almost everything done in the run-up to the days of the killing, usually by characterising what was better described, we would suggest, as bizarre behaviour, as evidence of planning. Three things in particular featured prominently in the prosecution submissions and do in their response, the respondent's notice, set out in my skeleton argument. They were these: that he wore gloves earlier in the day of the killings to use the cash point machine. The court was told of this and shown the footage, but it was never quite explained how this was evidence of any planning. Wearing gloves, of course, in June may be odd, but hardly evidence, we would suggest, of substantial premeditation. Secondly, he bought some clothes at Primark, summer clothes at Primark, and changed into them just outside Forbury Gardens before the killings. It was never really clear what the link was between buying clothes and changing his clothes and the murders themselves, or how that was evidence of significant or substantial premeditation. And a curious feature of the case was that he appeared to attend the rubbish bins, the refuse bins outside of his flats, and captured on CCTV going to those communal bins on a number of occasions, which featured prominently in the prosecution submissions. Again, it was never really clear why it was, we concede, rather odd behaviour. It was never really made particularly clear why that was evidence of planning and premeditation. And that was perhaps the best example of confusing, strange behaviour with evidence of planning and premeditation.
Now, we're going to be concerned with what the judge found.
Of course.
So your submissions really need, if I may say so, to be directed towards the factual conclusions of the judge rather than the submissions of the prosecution.
Yes, he found in favour of those submissions in total that all this behaviour was evidence of planning and premeditation. And in particular, my lord, the purchase of the knife used to commit the murders.
Yes.
We would, of course, agree, that that is evidence of planning, but no more than that was required to commit the offence, rather than significant planning or premeditation. It could easily have been...
Just help me, if you would. What planning do you have in mind that resonates in this area, which is not for the purposes of committing the offence or trying to get away with it? Because, of course, we shouldn't overlook the fact of the razor that he took to harm himself, the judge concluding that the purpose was to pass himself off as a victim.
Yes. Well, planning can, of course, encompass weeks of often detailed planning towards the commission of offences, whereas this was, for example, the purchase of the knife, no more than arming himself, having bought it, with the weapon needed to commit the offence, in the same way that would take place in any, or might take place with any offence of murder, not necessarily, therefore, elevating it to the level required to suggest significant planning or premeditation. Committing the offence and then hoping to get away with it, we would submit, it is not what was in the mind of those devising the schedule when the phrase was used, substantial planning or premeditation. One of the other features of the case that the prosecution relied upon and the learned sentencing judge found the earlier visit to Forbury Gardens. It is a prominent feature in Reading town centre. Mr. Saadallah was seen to enter and exit on a day in the lead-up to the killings, a different part of the park. CCTV of that earlier incident showed him arriving and leaving, as I say, at a different exit. no suggestion he was in the area where the offences were committed. And it would appear that he did no more than attend what is, as I say, a prominent feature in Reading town centre. There were, of course, images of Forbury Gardens on Mr. Saadallah's phone, and that, of course, on one view might be evidence of planning, but they were cached images, images that would be, if, for example, a newspaper was looked at, a local newspaper was looked at, had images of Forbury Gardens on it, that image would cache on his phone rather than an image that was saved or downloaded onto a particular device. So in short, my Lord, our submission is that, of course, there is evidence of some planning. It would be wrong and unrealistic to suggest there isn't. But it's whether or not there is evidence of significant premeditation and planning, such as to justify the finding of the learned sentencing judge. Next, a murder in furtherance of the extremist ideology. Again, we concede that there is some evidence of links between Mr. Saadallah. We won't make the unrealistic submission that nothing can be advanced by way of that sort of connection. It is again a submission that there is not sufficient here to justify the finding, to then justify a whole life term. Many of the findings we would submit on the face of them were superficially attractive propositions suggested by the prosecution, but not necessarily real evidence of the murders being in furtherance of that ideology. Mr. Saadallah led a life utterly inconsistent with being a fanatical Islamist. So many parts of his life could never be reconciled with that as those as his beliefs. He smoked cigarettes, he abused alcohol, he took drugs, he self-harmed, he had tattoos. Those are features of his life, and were features of his life for very many years, that are utterly inconsistent, we say, with him being an Islamist extremist. There was other evidence in the case that he identified as a Christian, as much, if not more, than he did as a Muslim, something anyone genuinely fanatical about Islam would not countenance, even fleetingly. Much was made of the connection to Omar Brooks. We say a connection which was exaggerated and overplayed. There was a 3-month period when they shared a prison in 2017, at a time when Mr. Saadallah was described by prison staff as vulnerable. That link, that connection in itself, or along with anything else, is insufficient, we would submit, to permit this finding. Importantly, and we concede importantly, his utterings after the event, having stabbed the victims, and his references to jihad, of course, something the court will be perhaps most concerned with. But at the police station, it's important to recognise that he, along with suggesting this was jihad, mentioned a number of other reasons as to why he may have become involved and committed these offences. Self-defence was mentioned, his sister being harassed on Facebook, referring to the victim's sexuality, and a desire to be deported, were all explanations given alongside jihad as reasons as to why he had committed these offences. There was, of course, his connection and the fact he had been a child soldier in Libya. And we would suggest that an unfair conclusion was reached about that particular aspect of the case. He was a 15-year-old boy at the time. We would say unfair in those circumstances to suggest that these offences 11 years later somehow were steeped in that conduct in Libya when he was a child. So we would submit that the two features for the learned judge to determine at the trial of issue. Both, we would submit, he fell into error. Neither of those two features, we would suggest, that was there sufficient evidence to justify elevating this from the 30-year starting point to the whole life term. Once the judge had made those two findings, there was really only one way that the imposition of a whole life term would be avoided. And that would be whether or not the learned judge decided that he suffered from a mental disorder which reduced his culpability so as to make the imposition of a whole life term unjust. Well, we do concede the weakness of our position in respect of this. We had no medical evidence to put before the court.
Well, there was some medical evidence, and the expectation was that two psychiatrists would attend, give their evidence, be cross-examined, and the judge would have the benefit of that. But on behalf of the applicant, a decision was taken not to use the medical evidence. So as you say, it puts your argument in, it might be thought, some difficulty on this front.
Considerable difficulty, and the best I can do is the best I could do then, which was to point to the medical records that revealed he had long-standing mental health problems, including post-traumatic stress disorder and an unstable personality disorder. But we have to concede, and I'm very realistic about this particular part of our submissions, that without supporting expert evidence, it's an uphill struggle to suggest or to establish that his mental disorder was such as to reduce his culpability. But there were long-standing mental health problems, but I concede the limitations of that as a submission. Finally, my Lord, he did plead guilty, and his pleas were entered just as soon as any of the psychiatric defences had been explored and reported on. And of course, even with offences of this gravity, the court is obliged to consider whether or not those guilty pleas have any effect on whether or not the sentence can be reduced from a whole life term, whether or not the imposition of a whole life term is affected by the fact he has entered those guilty pleas. We suggest it's important. His age, he's 26, and of course it's again unrealistic to describe him as a very young man, but he does have most of his life left to lead. That makes the likelihood of there being long-term risk, or a reduction in that risk, a genuine rather than a fanciful possibility, and we submit his age and his guilty plea were perhaps afforded insufficient weight in the overall context of these submissions. So in summary, my Lord, we submit that the learned judge was wrong to make Mr. Saadallah the subject of a whole life order. The findings of fact are unfair and fail to acknowledge the mental health conditions. It is conceded, of course, that when taken together, these offences are grave and justify a very substantial minimum term. But it was not necessary in our submission to impose upon him the sentence of last resort. Therefore, the sentence is manifestly excessive. Those are the submissions I make on his behalf, unless, of course, I can assist my Lord or my Lady with anything else.
Well, thank you very much indeed, Mr. Scamardella. That was extremely clear. Yes, Ms. Morgan.
My Lords, my Lady, the respondent respectfully submits that this was one of those rare and exceptional cases where the sentencing judge, Mr. Justice Sweeney, was correct to determine that the offending fell within the exceptionally high category of seriousness, necessitating the imposition of a whole life order. Before turning and outlining our submissions in that regard, may I begin with observing that this was a case which caused unimaginable shock, trauma, and grief for the families of James Furlong, Joseph Ritchie-Bennett, and David Wales. And I know that the court has had regard to the victim personal statements prepared by a number of family members. It also, of course, resulted in considerable trauma to the victims of the attempted murder offences as well. Turning then to the submissions, my Lord has the respondent's submission set out in our notice.
Very helpful and very succinct.
And in light of that, it may be that there is no real benefit in rehearsing those submissions for the court. My Lord knows that those written submissions contain the basis upon which the respondent respectfully submits that there are in fact 3 routes that justify the imposition of a whole life order in this case. The 2 that have been addressed by my learned friend, namely the murder of 2 or more persons involving a substantial degree of premeditation or planning, the murder done for the purposes of advancing a political, religious, or ideological cause, but also the overall seriousness of the totality of the offending, that being a feature which Mr. Justice Sweeney concluded justified the imposition of a whole life order. And so we respectfully submit to the court that there are 3 well-founded routes, and there is nothing in the submissions that have been advanced to undermine or suggest that Mr. Justice Sweeney was in any way incorrect to reach the conclusions that he did. And further, we submit, as my learned friend has realistically conceded, that in light of his failure to rely on any expert evidence in support of submissions advanced under paragraph 11C of Schedule 21, the court was bound to rely upon the clear and cogent conclusions of Dr. Blackwood, who made it emphatically clear that the appellant's culpability for his offending was in no way reduced by virtue of any possible mental disorder. In short, those are the submissions, unless I can assist the court any further.
Thank you very much indeed. Mr. Scamardella, is there anything you wish to say in reply? Well, we will rise for a few minutes to reflect upon the submissions we've heard. On the 20th of June 2020, the applicant went to Forbury Gardens in Reading, having the previous day purchased a large kitchen knife and there murdered Joseph Ritchie-Bennett, David Wales, and James Furlong. His attack was swift, precise, and deadly. None had time to react. He then attempted to murder Stephen Young, Patrick Edwards, and Nishi Nisundan. On the 11th of January 2021, he was sentenced to life imprisonment with a whole life term. That means that unlike those who have a minimum term of incarceration attached to a life sentence, the parole board will never be called upon to decide whether it is safe to release him. The judge decided that these multiple murders involved a substantial degree of premeditation and planning. He also concluded that the murders were committed for the purpose of advancing a political, religious, or ideological cause. He rejected a submission that the applicant's culpability was reduced by reason of any mental illness. The application for leave to appeal against sentence has been referred to the full court by the registrar. In support of the application, the applicant advances 3 grounds of appeal. First, that the judge should not have concluded that the offences involved a significant degree of premeditation or planning. Secondly, that the judge should not have concluded that the killings were done for the purpose of advancing a political, religious, or ideological cause. Thirdly, that the judge was wrong to conclude that the applicant was not suffering from a mental disorder which lowered his culpability for the offences. In short, Mr. Scamardella, Queen's Counsel, who has appeared for the applicant this morning, accepts that there was some degree of planning and premeditation, but submits that neither reached the threshold necessary for the purposes of sentencing to a full life term. Similarly, he submits that whilst there was evidence of some ideological motivation, the evidence did not sustain a conclusion that the purpose of the attack was to further such ideological cause. For reasons which we will explain, we have concluded that there is no substance in any of the criticisms made of the judge's conclusions. In those circumstances, we refuse leave to appeal. A sentence of life imprisonment is mandatory following the conviction of an adult for murder. The applicant was 25 years old at the time he committed these offences. Schedule 21 to the Sentencing Act 2020 sets out a series of starting points for minimum terms to be attached to a life sentence, depending upon a number of factors identified in the schedule. A whole life tariff is appropriate only in limited circumstances of exceptional gravity, and only for an offender aged 21 or over, rather than 18 or over. Paragraph 2 of Schedule 21 provides, subparagraph 1, if A, the court considers that the seriousness of the offence or the combination of the offence and one or more offences associated with it is exceptionally high, and B, the offender was aged 21 or over when the offence was committed, the appropriate starting point is a whole life order. Subparagraph 2 Cases which would normally fall within subparagraph 1A include A, the murder of 2 or more persons, where each murder involves any of the following: 1, a substantial degree of premeditation or planning; 2, the abduction of the victim; or 3, sexual or sadistic conduct; B, the murder of a child, if involving the abduction of the child or sexual or sadistic motivation; C, the murder of a police officer or prison officer in the course or his or her duty, where the offence was committed on or after 13th April 2015; D, a murder done for the purpose of advancing a political, religious, racial, or ideological cause; or E, a murder by an offender previously convicted of murder. It was common ground that the judge could take into account the 3 attempted murders in deciding on whether there should be a whole life term or a minimum term. The case for the prosecution before the judge was that the seriousness of the offences was exceptionally high for the purposes of paragraph 2(1) and fell squarely within the subparagraphs 2A1 and D. By contrast, the case for the applicant before the judge was that the starting point should be a minimum term of 30 years custody, albeit moved upwards to reflect aggravating features. The applicant had pleaded guilty on the basis that the criteria for a whole life tariff were not satisfied in his case. That was not accepted by the prosecution. It thus fell to the judge to resolve the disputed issues at a hearing convened for that purpose. The applicant did not give evidence in support of his basis of plea. Neither did he, in the end, rely on expert psychiatric evidence. The applicant arrived in the United Kingdom from Libya in October 2012. He made a claim for asylum, which was refused. He admitted involvement with an extremist Islamist militia, but denied direct military activity. He claimed to have fled Libya after refusing to perform acts of violence and torture. The applicant twice went to prison in England before committing these murders and attempted murders. He had 6 convictions for 16 offences, including 2 for racially or religiously aggravated harassment, 8 for offences of violence, and 2 for possession of a knife or bladed article. He went to prison in January 2017 and there associated for some months with a radical preacher. After release from prison on that occasion, the appellant again got into trouble and was detained at the end of 2019. He was released on the 5th of June 2020. Following his release, he returned to his flat in Reading. Between the 15th and 20th of June, he accessed various extremist websites. On the 15th of June, he began searching for images of Forbury Gardens, and on the 17th of June made a series of trips to the gardens, which the prosecution characterized as reconnaissance trips. He spoke to his probation officer on the 18th of June, who was concerned about his mental health. He was visited the following day, the 19th, by members of a mental health team, but he did not let them in. He later spoke to police officers who visited his flat and dismissed any concerns about his mental health. He purchased the knife that he used in the attack on the 19th of June. The prosecution case was that given the applicant's previous military training, the knife was carefully chosen to ensure that he could inflict swift and fatal injury with its use. On the morning of the 20th of June, the applicant purchased new summer clothes, and shortly before 6 o'clock in the evening, he left for Forbury Gardens. After the attack, he attempted to destroy his mobile phone, which contained evidence of his interest in Islamist activity, before he made his escape. As he carried out the attacks, he shouted out, "Allahu Akbar," and did so again in the aftermath. Following his arrest, he made repeated references to having carried out an act of jihad and said that he would go to paradise. Mr. Scamardella reminds us that he gave other explanations for his offending. In the interview between the 23rd and 25th of June, the applicant behaved very oddly indeed, including howling like a dog, answering questions with random comments, and suddenly doing press-ups. Dr. Blackwood, the psychiatrist instructed for the prosecution, concluded that this was a fabricated attempt to feign mental illness. The applicant's medical records contain a long-standing history of mental health problems. Dr. Blackwood concluded that the applicant was not suffering from any major mental disorder which affected his culpability for the offences. He considered that the applicant suffered from unstable personality disorder. He had some post-traumatic stress symptomology which fell short of the threshold for PTSD. As we have indicated, that was the only expert evidence before the judge because the applicant abandoned reliance on evidence obtained on his behalf. The judge also had available to him evidence of various psychiatrists who examined the applicant in the days following the attack whilst he was first in custody. In the course of his exemplary sentencing remarks, the judge made a series of factual findings. They included the following. 1. In 2011, as a teenager in Libya, the defendant was trained to fight and fought for a period of at least 8 months as a member of the extremist Islamic militia Ansar al-Sharia, which is now proscribed in this country, doing so both during the uprising against the Gaddafi regime and after the fall of that regime. 2. When in the autumn of 2012 the defendant applied for asylum in this country, he lied about his role in Ansar al-Sharia and as to the circumstances in which he came to part from them. 3. The defendant held extremist Islamic views whilst in Ansar al-Sharia and continued to do so, albeit with lapses, for example, in relation to drink and drugs, up to and including the events on 20 June 2020, as illustrated by his retention of militaristic images relating to his time in Ansar al-Sharia, his interest in the radical preacher Omar Brooks in 2017, the images he viewed in 2017, 2018, 2019, and using a Huawei phone in the run-up to the 20th of June 2020, it being no coincidence that resultant cached images in June 2020 included Martyrs of Volcano of Rage and the ISIS flag, and the writing that was found at his address, together with what he said when he carried out the offences and thereafter. 4. After his release from a prison sentence on 5th June 2020, the defendant began to plan his attack and by the 15th of June had identified Forbury Gardens as a potential venue for it. On 17th June 2020, he reconnoitred Forbury Gardens and confirmed it as the venue. 5. Against the background of his combat training and experience, the knife that the defendant bought on 19th June 2020 to carry out the attack, which had an 8-inch blade, was chosen with care to ensure the maximum likelihood of swift, fatal injury each time it was used. 6. The clothing that he acquired and wore on 20th June 2020 was intended to allow him to blend in with others in the gardens so as to achieve maximum surprise when his attack was launched. 7. When the judge left home to carry out the attack, the knife was in the backpack that he took with him together with a plastic razor. His intention, for the purpose of advancing his extremist Islamic cause, was to kill as many people as possible in as short a time as possible, and thereafter to escape, then to injure himself with the plastic razor in the hope that he could pass himself off as a victim. 8. On initial arrival at Forbury Gardens, he went to the side gate from where he had a view of the two groups sitting on the grass and decided that it was them he was going to attack. He then crossed over the adjacent road and went to the bin area next to some trees in front of the Vino bar, where he began final preparations for his attack. He took off the rucksack, put the knife down his shorts, and then, clearly appreciating the incriminating nature of what he had been looking at on the internet since his release from prison, endeavored to smash his Huawei phone. Leaving the rucksack, the plastic razor blade, and the smashed phone behind, he then set off to carry out his attack. 9. Having entered the gardens, he waited until he was close to the first group and then commenced his attack with ruthless speed and brutality, such that James Furlong, Joseph Ritchie-Bennett, and David Wales had no chance to react, let alone to defend themselves. Using his combat experience in each of their cases, the defendant targeted a vulnerable area where a single thrust of the knife would, as he intended, inevitably cause death. 10. It was the loss of the element of surprise that saved Stephen Young from the same fate, and, although the defendant sprinted across to the second group, saved Patrick Edwards and Nishit Nisuddin as well. During the course of his attack and afterwards, and because he was seeking to advance a political, religious, or ideological cause, the defendant was shouting in Arabic, "God is the greatest," and "God accept my jihad." The defendant, 12, the defendant managed to escape from the gardens, jettisoning the knife as he went, and returned to the area outside the Vimo bar where, as planned, he cut himself with the razor and then endeavored to make off. However, he was followed and arrested. 13, at the police station, he admitted on a number of occasions that what he had done was jihad in the sense of the word used by extremists, and that as a result he was going to paradise. End quotation. As can be seen, the judge made findings of fact on the two different bases, which placed the applicant squarely within paragraph 2 of Schedule 21, namely that he murdered 3 people following a substantial degree of premeditation or planning, and also for the purpose of advancing a political, religious, racial, or ideological cause. The short question for this court is whether it is arguable on the material available to him that the judge was not entitled to make those findings. In the summary of factual findings, which we have quoted, the judge himself identifies in succinct terms the reasons why he made those factual findings, which led him to the conclusion that for the purposes of Schedule 21, the seriousness of the murders was exceptionally high. There was a wealth of material summarized by the judge that supported the conclusion that the motivation of the applicant was ideological and the cause of his attack. It involved not only a meticulous examination of his background, connections, and involvement in Islamist activities, but was also powerfully supported by what he shouted as he carried out his murderous attack, and also by what he said afterwards. The planning and premeditation in this case was clearly substantial for the reasons identified by the judge. As we have noted, there was an overlying argument raised on behalf of the applicant, namely that he was mentally ill in a way which reduced his culpability. That was advanced in support of the contention that even if the two criteria identified by the judge, which specifically took this multiple murder and associated attempted murders into paragraph 2 of the schedule, were established, nonetheless culpability was reduced and a whole life order was thus inappropriate. Realistically, this morning, Mr. Scamardella has recognized that in the absence of expert evidence to contradict Dr. Blackwood, and in the face of an explicit decision not to rely upon the expert evidence which was available to the applicant, that there are difficulties in sustaining this submission. It is sufficient for us to note that the judge had available to him the applicant's medical records, which chronicled the mental health difficulties. He had Dr. Blackwood's report and the others to which we have referred. The judge explicitly indicated that he had referred to the definitive guideline recently issued by the Sentencing Council in relation to sentencing offenders with mental disorders. His conclusion was that he was sure that the applicant was not suffering from a mental disorder or mental disability which lowered his degree of culpability for any of the offences. He set out in his sentencing remarks at some length the reasoning which led him to that conclusion. It is for the judge to make the necessary findings of fact in connection with determining a proper sentence. This court will interfere with such conclusions only in limited circumstances. The essential question is whether the factual conclusions were open to the judge on the material before the court. Each of the conclusions reached by the judge and which are challenged by the applicant were, in our judgment, obviously open to him. We consider that those on premeditation, planning, and the underlying motivation and cause were, in truth, inevitable conclusions. The conclusion on mental health followed a careful evaluation of all the evidence that was before him. In those circumstances, the whole life orders made by the judge cannot be stigmatized as even arguably wrong in principle or manifestly excessive. In the course of his sentencing remarks, the judge referred to the victim's personal statements, telling of the profound impact that the deaths of James Furlong, Joseph Ritchie-Bennett and David Wales has had on those left behind. He referred to the victim personal statements of Stephen Young and Nishit Nisudan, who survived the attacks. There were also statements made on behalf of Reading Borough Council and the Thames Valley Police to explain the adverse impact on the town as a whole of this applicant's shocking crimes and the steps they had taken to try to heal the collective trauma. Dealing with an application of this sort inevitably requires an analytical approach to the evidence and arguments. However, none should forget the consequences of these murders and attempted murders, or those left behind and injured, or indeed the impact on Reading. Like the judge, we do not forget the families, friends, and professional colleagues of those who died, or those who were seriously injured who must live with the consequences. But we are satisfied that the judge's approach cannot be faulted, and there is no basis for suggesting that the whole life order was wrong in principle or manifestly excessive. Thank you.
Mr. Saadallah, can you hear me? Thank you very much, sir. That concludes the reading of your application for leave to deal against your sentence. As you heard, your application was refused by this court, and your sentence remains one of a life imprisonment with a whole life term. Thank you very much, and I will now terminate the platform. Thank you.
Mr. Scamardella, Ms. Morgan, thank you very much indeed for your submissions, and we extend our sympathies to all those who have been deeply affected by this tragedy.